So if you want to be a mediator, the way the rules are now, you abide by their rules.
But I mean, we all know a lot of district court, I mean, judges that retire and go into mediation. I guess I don't mediate. I mean, I have done some very limited many years ago, but I just feel like we're putting a lawyer in a difficult position by having conflicting opinions.
Well, I think that the plan, as I see it, the way to sort of thread the needle is our rules govern the conduct of lawyers, and their rules govern the conduct of mediators. And if a non-lawyer mediator, for instance, has to
Right.
abide by theirs, and if they say you got to withdraw, then I think they can make that happen. If we don't think you have to withdraw, then I think we can say it is our view that you do not have to withdraw from a professional responsibility. But if you've got to do that to satisfy the DRC, then you got to do that. Or if we don't think that giving that telling people that you cannot agree to violate the rules, that's legal advice. I don't think that's legal advice. I think that is the same way that if I saw another lawyer doing something and I told him that I thought he was violating the rules by doing that. I am giving him legal advice because that's my opinion about how I interpret the rules. But I don't see anything wrong with a lawyer doing that. In fact, when people turn in or report lawyer conduct to the state bar, they are in fact making they are saying, I think this guy or this man or woman is doing something that is in violation of the rules. So I think people do that all the time. And I don't think in my view, that's not prohibited conduct for lawyers. That may be prohibited conduct for mediators, but I view the DRC's job is to regulate mediators and our job is to regulate lawyers. And we should do what we think. I think it's easier for us now that they have opined on this, but I think we ought to do what we think is the proper thing in regulating the professional conduct of lawyers.
Let me read to you what's in our opinion number 7. To meet his professional responsibility, mediators should consider withdrawing from the mediation or taking such action as may be required by the standards if the lawyers insist on conduct during the mediation that violates the rules of professional conduct. So our opinion is discretionary, is like you should consider withdrawing, but then also follow what the rules of the DRC standards require.
I mean, my problem with the withdrawal thing, and the reason that is that if if you may have somebody who doesn't realize that you can't. In fact, this happened to me within the last year. I had a lawyer who was having a conflict, and they asked me to represent them in the conflict. And the other lawyer making a claim said, "Well, we can settle this claim. I won't report this conduct to the bar." And I wasn't the mediator. I was the attorney for lawyer A. And lawyer B had proposed that they settle the case. And part of the settlement terms were, if you pay me $10,000, or whatever it was, we won't report your conduct. And I said, we're not putting that in a release. We're not putting that in a letter. We are never agreeing to that term. And I will not, and I'll tell the other lawyer that we can't do that. David Allen, will tell the other lawyer as counsel for lawyer A that you cannot propose a term like that, and we certainly cannot agree to that, even though it might be in my client's interest. So I think that, Nicole, I think that's the proper standard here. And I also think if you were a mediator, and I am a mediator, and I know Wade is, I don't know what anybody else is, but if you get close to an agreement and somebody proposes a term like this, and you just say we can't do that, the mediation still might continue because that person would go, "Oh, I should have had a V8. I didn't realize that was something I couldn't do. Well, now we'll do this and such." And so I don't think that mandatory withdrawal. I don't think withdrawal is mandatory. It may be that if they say, "Well, I want that term in there," then you can say, then the mediation's over. I mean, you might do that, but I don't see anything wrong with telling the other lawyer, as I did in the case where I was one of the parties. You can't propose a term like that, and that's not proper, and we won't consider that.
Yeah, if I can throw out a thought, I don't see these provisions as being in conflict necessarily in kind of in practice. Because ours is quoting a comment from 8.3, and whether or not a lawyer should consider withdrawing if there's something going wrong that the lawyer just cannot participate in. But our opinion does say lawyer cannot participate in I guess the I don't know, you want to call it the making or proposal
Sharing the
or
terms,
transmission or what have you of this particular term. So that's already just a no. I
Right.
see their opinion as saying if the lawyer who's proposing the term refuses to relent on this, then lawyer mediator, then you have to withdraw. And so I see that as actually kind of working with our opinion, because we're already saying lawyer. I think we're actually saying the same thing, that if a lawyer cannot, as a mediator, cannot participate in this proposal becoming a part of any sort of agreement. And so although ours kind of has the language of should consider withdrawing, that is an option early on. Another option would be to do the things that the DRC opinion says, which is contact ethics advice. They give them a copy of the opinion. They do all these things to kind of inform the lawyer. One thing that I think that we could, if we wanted to, we have it at the very end, it's the very last sentence of our opinion. If the lawyers or parties do not discontinue discussion or inclusion of the term in their settlement agreement, mediator should withdraw from the mediation. If you all feel that should be mediator shall withdraw, I do think that's consistent. I don't think that materially changes, although should versus shall clearly is that's a material difference in a word. But I think the principle that's articulated in the opinion is the same. But I guess that's all to say, I see our opinion as working with theirs. Theirs is a little bit more clear of just if a lawyer is stubbornly insisting on a provision that violates the rules, mediator, you have to say, I'm out. And I think we kind of are saying the same thing, but maybe not as forcefully. So maybe that's a question for the subcommittee. Do you think that very last sentence of our proposed opinion that says mediator should withdraw, is it worth considering changing that to mediator must withdraw if the lawyers just insist on doing something that violates the rules?
Wade and then Fran.
Well, I think the problem is the timing, right?
Yeah.
So let's say I'm in a mediation, I'm the mediator. Somebody mentions this to try to get some leverage with the other side, right? And I'm aware of this rule, and so I flop it down on the table in front of the guy and say, are you aware, in the true Socratic method, are you aware of this rule? I don't care about the rule. Well, I'm a state bar counselor. I sit on the ethics committee. You're an attorney. You're licensed to practice law in North Carolina. This is a rule that attorneys who practice in North Carolina are supposed to follow. And now I'm feeling kind of stupid now, right? Because I should be able to say to the guy, look, this is an ethical rule. You're getting ready to get yourself in trouble, and you shouldn't do this. You shouldn't even ask for this. I can't take it to the other side. I have to withdraw if you don't back off, right? So at that point, I mean, mediation is about getting people to understand what they need to do, right? If everybody mediated the way the DRC wants us to mediate, no cases would ever get settled. I mean, it's just it's just the truth. So I don't think as far as I'm concerned, I'm a lawyer. The North Carolina State Bar is the dog. the DRC is the tail of the dog, right? If I wasn't a lawyer, I couldn't make that little metaphor. But I don't think we need to worry about the DRC. I think what we need to worry about is giving lawyer mediators enough flexibility so that we can do our job as lawyers in the context of a mediation. And I'm sorry I'm so long-winded about it, but and it's partly me, right? Because when I was part of the initial rulemaking, Andy Little and I wrote the rule for family financial mediation. And he agreed with me that if two people wanted the guy down at the 7-Eleven to mediate, they ought to be able to choose that person, whether they were certified or not. The only reason he did it was because at that point in our history, lawyers simply would not be certified mediators. Nobody would pay the money. So he knew that if the thing was going to get off the ground, that rule could not be the way it is now. And it took about 2 decades before they changed it. But what that's done now, and this is an example of it, it's put into relief the difference between a lawyer mediator and other mediators. And honestly, we need to give ourselves some grace as mediators, as lawyer mediators. And it may well be that some mediators like me, if they want to say you can't mediate anymore because you violated some silly rule about not telling somebody that it's an ethical violation, fine. Take it. I don't feel the same way about my license to practice law.
All right, Fran,
I'm sorry.
Fran?
Yeah, I was just giving the thumbs up to Ryan's suggestion to change should to shall, but I mean, Wade is in the trenches and, I'll defer to him and the committee if y'all decide differently.
Yeah, I guess what I'm trying to do, Brian and Nicole, this may be wrong. This may be beyond the scope of what we're doing here, but like in my situation where it was not a mediation and a lawyer proposed a term to me that says, I think your lawyer committed malpractice and but I'm willing to settle the case and not report your guy to the bar if he'll pay me X. I mean, we can't do that. I could not do that. And I saw no problem in telling the other lawyer, first of all, you can't do that. You cannot agree. You reporting lawyer or a lawyer for the wronged client cannot agree not to report my guy. I don't care how much money my guy pays you. If you have an obligation, if you are required under the rules to report this, you have to do that. And we are not going to put a term in that says you can't. And that's really what we're talking about here when the lawyer is wearing the mediator hat. I'm much more concerned, and I think this may be what Fran is talking about, and maybe what Wade's talking about. I'm much more concerned about regulating the lawyer conduct here as opposed to the mediator conduct here. I'm gonna let the DRC worry about the mediators, but this is a rule, or excuse me, this is an opinion which could also help lawyers understand their responsibility in the negotiating process, because that's really, we're likely to encounter that. More lawyers are likely to encounter that problem, the one I just described, than they are as lawyer mediators. But I don't think there's anything wrong with me telling that other lawyer, I'm not going to do that, and B, you should not have done that, and here's why.
So,
David, my client said, I'm happy to pay them the money if they want to support me. And I'm like, yeah, you got to get yourself another lawyer if you're going to do that. It's going to be me, but.
Well, so David, what you just said, I feel like you're hitting on one of the things that I'm thinking, that when you said kind of the first thing, I would tell that person, I can't do this. And second, you can't do this. I think the DRC has a problem with the second part. Right. The mediator telling somebody else you can't do that. I wonder if some feedback that we could provide the DRC, because I think we're focusing in on on their best practice for mediator lawyers section, these 6 points. The number 2 is the one that says the mediator lawyer is prohibited from giving advice, shall not advise the party or their counsel the terms in violation of the RPCs. I wonder if we should provide feedback to the DRC that it would be helpful and maybe clarifying for them to include, however, the mediator lawyer is allowed to state that it would violate their ethical responsibilities to participate in this.
Yes.
Now, they might not be saying that violates the rules. You can't do that, lawyer, but they can at least say, I have a responsibility as a lawyer and I can't participate in this. And here's why. Here's this ethics opinion. And frankly, my participation in this, while I haven't proposed it, that is a violation of 8.4a because you are engaging in misconduct through the course of someone else's conduct. So I guess maybe that could be some feedback to them that just to add clarifying language that the lawyer mediator is allowed to articulate his or her professional responsibility regarding that situation. So that's one thing. And the other thing is I think we're on point 5, about withdrawal. And that's where I feel like our opinions do work. I think our opinion saying the lawyer should withdraw from the representation still works. And it's kind of getting at, I think ours kind of accounts for the timing. It doesn't come to that final resting place of everyone's being stubborn. I've tried every alternative and nobody is willing to budge. They're insisting on moving forward. Well, this opinion says I should withdraw from representation. And I think lawyers would read that and they would say, oh, then I will, as opposed to a shall. I guess when I suggested the should versus shall, I do think shall is much clearer, but and I think it would be still appropriate because that opinion or that sentence at the end of our opinion is kind of if all else fails, then yeah, you're left in this spot where moving forward means that you, lawyer mediator, are violating the rules and you can't do that. So yeah, you have to withdraw. You should withdraw. You must withdraw, however we want to point it or put it there. But I guess all this to say, I still think our opinion works with their opinion, even if we leave it at should. But I wonder if that second point about a lawyer mediator being allowed to articulate their professional responsibility might be helpful language for them to include in this opinion.
Yeah, I think so. I think that's how I interpret what Fran's question was, is that ultimately, and this is what their opinion says, if the lawyer does not, the proposing lawyer does not withdraw the term from the negotiations, the mediator lawyer shall terminate. That's right. I mean, Fran is right. You cannot go forward and participate in the mediation if this knucklehead insists that term be on there, because you, as Wade said, you are then violating the rules of the state bar, and you have to terminate the mediation at that point. So now, Fran, does that cover what your point was? Is that if you can't, as the mediator, you can't go forward with this thing if the idiot says, that's our proposal, you take it in there to the other side, you cannot, as a lawyer, facilitate the violation of the rule, which is what that would be.
I mean, sounds like Ryan is changing his opinion on the should versus shall. I still prefer shall. I just think it's clearer. But again, I'm not going to hold the process up. I don't feel that strong. If everybody else is happy with should, I can get on board.
Yeah. Wait.
Well, one thing that the only real authority that a mediator has is to declare an impasse. So mediation has become a requirement for equitable distribution matters in all across the state. If you don't mediate, you can't get a judge to decide your ED case. The mediator's responsibility is to bring the parties together and to try to enhance negotiation. Mediator has no power other than to declare an impasse. So that's a big deal. until the mediator declares an impasse, the people are sort of forced to talk through this stuff, right? And they come at it from all different levels of experience and expertise and preparation. So making it should instead of shall, I think gives just a skosh of additional authority, perhaps, and flexibility to the mediator. And I think that's worth having. Secondly, I think it's appropriate for the state bar to say to the Dispute Resolution Commission, you can't tell us what our lawyers are supposed to do with regard to informing people about ethics opinions. That's not your responsibility. You can say whatever you want to non-lawyer mediators, but to lawyer mediators, this is what they have to do. And that makes it clear to them, you know. And you know, as a practical matter, I don't think they want to lose all the lawyer mediators in the family financial mediation context. I just don't. I think that they're like every other user fee financed agency, and it's about the money. So I think we need to stand up for our lawyer mediators and draw a line and draw a boundary and say, if you're going to be a lawyer and you're going to be a mediator, then you need to tell these people what this rule says. So anyway, that's why I wanted to get on this panel, because it's different. You know, it's different when you're a mediator. It's like David. You know, when you make David the chair of a committee, he doesn't talk as much.
Tries not to.
Well, I agree with everything that y'all are saying. I do think this is where when I maybe, and to your point, Fran, I don't know that I was necessarily changing my opinion as much as before. Maybe I just wasn't clear enough saying I don't really know what the right answer is. Should it be should versus shall? That just kind of occurred to me in this first or in our conversation, and I think both work. I hear what Wade's saying, that there's like a little bit of squishy that might be needed for mediators, and that's something that I'm gonna, like you said, Fran, I'm gonna have to defer to Wade on that. But to me, that's where I'm looking at the opinion, and even to your point, Wade, you know, as much as we originally did say lawyer should, must inform, whatever the original language was, you know, the DRC basically has their opinion, and I know there's a part of me that wants to say, well, listen, this is what lawyers need to do. I do think we found a bit of a compromise. It doesn't require them to change their standards while still maintaining the integrity of our profession, because we're basically saying an opinion 7, and I think they've kind of adopted some of that themselves in their different points here, that a lawyer mediator has options, and it might not be directly saying that violates the rules and you can't do that. As much as this one feels very clear, I guess I wonder if their concern is the other scenarios. This one is one that, like, if you propose this term, you can't say that. And I think everybody agrees with that. But other things where it's like, well, no, I think that violates the rules because I think you actually engage in some sort of misconduct by maybe withholding some information in the original discovery process, whatever it might be, and you get into some sort of just mess of ethical discussion. But I think here, they and our opinion, both opinions are basically saying you can, you know, withdrawal is one option, or telling the person you need to call for ethics advice, or here's a copy of this opinion. And I think that would, I guess that's where I look at our language and their language as offering guidance for other scenarios where there's an opinion on point and the mediator is just like, I know there's an opinion out there. I can't tell you what to do, but I can lead you to the water. and it's up to you to drink it. But I'm not going to advise you, lawyer, on your ethical responsibility directly. So yeah, I feel like I feel like this personally, I feel like the opinion actually kind of works with theirs. Um, if especially if they included some language about a lawyer mediator being allowed to articulate their professional responsibility. And the should versus shall, like I really remain torn. I mean, I'm trying to let my gut reaction kind of flow out here. And I'm thinking out loud because the shall is very clear, especially for the grievance process. You know, if you say like, well, lawyer, you were supposed to withdraw. They insisted on keeping this thing in here. You told them about the opinion. You told them you couldn't participate, and yet you didn't get out of the mediation. The lawyer says, well, the opinion says I should. It doesn't say I must withdraw. Now, to be clear, I'm having a hard time imagining a scenario where the grievance committee is actually facing this type of complaint. I don't think we're talking about something serious, significant in that regard. But point is, if you ever have to wrestle with this, a shall is much clearer than a should.
Yeah, I think that's right. And I think if I don't see how you can do this, Brian, and transmit that term without aiding and abetting the violation of the rules. And so I don't think the mediator can do that. At the last, when nut cutting times comes, if in fact this knucklehead insists that this term be transmitted to the other side, you the lawyer cannot do that. I mean, I'd have a real problem with their number 2 in the DRC's rule, which says the mediator is prohibited from giving legal advice. I agree with that. That is, in fact, that's their purview. But then it says they shall not advise the party that the terms in violation of the RPCs. I think we do that. I think lawyers do that to other lawyers. They should do that when they think that has happened. And if that in fact is what has happened here, and this person refuses to acknowledge that, and you hand them the opinion, or you say, you need to look at RPC 303, and it says you can't do this, and you're telling me that you want me to do that, I am not going to do that. And if you can insist on that, then this thing is over. And I think it has to be over, because otherwise the lawyer mediator, if there's an indiscretion there, then we are giving him discretion to violate the rules. And I just don't think that we should do that. So I have a problem with their number 2. And if we're going to comment to them about our advice to them, is that I think that's wrong. But I don't think our opinion can condone a lawyer being involved in any way in the violation of the rule by transmitting that term. I think that we have to say that you can't do that. So I guess I'm on the shall side. If you have exhausted your efforts to try to bring this person to their senses, and they say, I don't care what you say, Mr. Mediator, this term has to go to the other room, you can say, I think that I don't think that has to happen, actually. I don't think I have to do a damn thing here, and I'm declaring an impasse, and you have to get a new mediator.
I agree. I would agree to shall if our opinion makes it clear that a lawyer mediator is obligated to tell the person that the lawyer mediator believe this to be an ethical violation. I mean, I think that's our responsibility.
Yep.
As lawyers. Because if you tell them and they don't get it and they don't buy it, and they're trying, then you become complicit, right? But if they say, oh, you can't tell them, right? But yet you gotta end the mediation, that doesn't seem to me to make any sense at all.
All right, anybody, Elizabeth, you've been remarkably restrained given all of this. You must be the chairman of this committee, because Wade said the chairman wasn't supposed to talk.
What I am is not a mediator, so yeah. Well, my only new question now is, I agree with what you all have said, particularly on the point about not tying the lawyer mediator's hands on sharing why in fact they need to leave, because it just gets weird at some point. But is Brian's suggestion about redirecting the guidance a bit more likely to bring us to a workable conclusion? Because Wade, I thought what you were just describing goes directly against what they just told us last time they couldn't abide. I don't agree with them, same as you, but just to, finish it up, going with Brian's approach struck me as maybe more acceptable to them and more likely to get us to a place where we can put this out and help anybody who's got some indecision. Does that make sense what I mean?
Brian, you think you can get this thing handled with Fran?
Yeah, I think
I mean Tara. I'm sorry, Fran. I
Tara,
was looking at your name as I said that, and I was like, "This is Tara."
Fran and me, we're gonna have some words after this. No.
I think you and Fran gonna get along just fine. You and Tara.
Yeah. I think so if I'm hearing, and Nicole, feel free to chime in here too. I'm hearing the subcommittee say the kind of two things. One is that we would like the DRC's opinion to well, I guess maybe we'll put it this way. While the committee does still disagree with number 2, we think the DRC's opinion should at least include some clarifying language that the lawyer mediator is able and maybe even should articulate what their professional responsibility is and why they cannot participate in the transmission or furtherance of that provision. So that's one thing. As for our opinion, I think maybe that I'm looking at that very last sentence of the opinion that talks about the lawyer should withdraw. I think we can make that sentence a bit stronger that says, if the lawyer concludes that participating in the transmission or furtherance of that proposal or that proposed term is a violation of the rules of professional conduct, and if after kind of exhausting their alternatives, the parties remain insistent on including the term that violates the rules of professional conduct, lawyer must withdraw.
Yeah.
And we make it nice and strong and clear for lawyers so they see, if I've tried everything and I know this violates the rules, I cannot participate. There's no squishy there. Yeah. Okay.
Love it.
Got it.
Seems to be consensus. I see lots of thumbs up and nods across the panel ribbon. So, okay, you are hereby commissioned to go and do that, but to send no further. Okay.
Easy peasy.
Just I love the benediction.
Yeah. Well, I hate to ask this because at my church now we'd be passing the plate, so y'all don't want me to do that. I'm just a good old Baptist. We don't ever miss a chance to.
Sorry, I gotta go.
Yeah.
But anybody else feel like that they need to chime in on anything here? Are we good? We're all singing off the same hymnal? Okay.
Yeah, I think we are.
All right. That's what we'll do. And hopefully we'll be able to put this thing to bed between us and the DRC in April, folks. And thank you. This has been a good discussion today. And, particularly, I won't say this just because Elizabeth's new to us, but this is how we finally figure crap out. And our friends on grievance say that we all talk too much, but we generally, these are nuanced matters. We sometimes make them more nuanced than
I get it. I think I accidentally volunteered to be on the one about fee increases because I was so interested.
You sure did. I made a note of that, Elizabeth.
I did.
Well, in that one, I'd like to see the terms that your client, because we've all been in situations, or many of us have been in situations where it's really a negotiation. Client says, you're getting our work, and here's what we're going to do, and that sort of thing. And it does sort of tell you what your rate structure will be and what's possible and that sort of thing. So that's why it's nice to have a spectrum of folks, because you get different experiences with the clients that in those situations are a little different for you than for some other folks. That's good.
Thank you, David. I've learned a lot from other folks. I don't personally have a lot of exposure to people who aren't practicing for faceless huge corporations, so that's nice for me.
And since there's a possibility that some member of the grievance committee might see this on YouTube, let me just say, all you grievance folks that make fun of ethics and think that we're just talking about stuff, you're the folks that come over to ethics and start chatting the most. because they all have an opinion. Everybody's got an opinion. So just come on over, nerd out. It's all right.
Well, those grievance people they do all have opinions, and there's always there's some more expression, but everybody's got opinions are like something. Everybody's got one, and I think that personifies grievance for us. Hi, grievance friends. Okay, thanks, guys. Great to see all of you.